So I want us to shift our attention to offenses relating to property. And offenses relating to property cover acts directed towards property, that is including theft, vandalism, fraud, and a breach of trust. Now, I want us to briefly look at theft, which is stealing. Now, theft is defined in Section 268 of the Penal Code, and it involves fraudulently and without a claim of right taking or converting anything capable of being stolen. Now, the actus rea elements of theft include, taking or asportation, that is moving the object or causing it to move, so that even slight movement from its normal place constitutes taking. The second actus rea element is converting, and this occurs when the accused is already in lawful possession, but then usurps the right of the owner. For example, a bailee who refuses to return goods or sells them actually converts those particular goods. Now, the mens rea element, that is the animus furandi of theft, include number one, intent to permanently deprive. And this is the intention, to entirely, repudiate the owner's interest. The second mens rea element includes specific intent. And this includes, intent to use the thing as a pledge or as security, intent to deal with it so that it cannot be returned in the same condition, or for money. And also intent to use it at one's own will, even if there is intent to repay later. Now, there is a case of Hawkins versus Republic of 1959, and the facts of this particular case were that an accountant received a check in his name from his employer to pay a creditor. Now, instead, he deposited it into his own overdrawn account to reduce his debt. And the issue was, does depositing a check meant for a third party into one's own account to reduce personal debt constitute theft by conversion? And the rule is that conversion occurs when a person lawfully in possession of property deals with it in a manner inconsistent with the owner's right, with the intent to deny those particular rights. And so the analysis of this case was that the court found that the accountant deviated from instructions and acted as the owner with no immediate intention to repay the creditor. And so the conclusion of the case was that the appellant was guilty of stealing by way of fraudulent conversion. Now, the second offense related to property is robbery, and robbery with violence. Now, these are aggravated forms of theft, combining elements of theft and assault. Now, I want us to look at simple robbery, which is covered under Section 295 of the Penal Code. Now, simple robbery is stealing preceded, accompanied, or followed by the use of force or threats of violence. But when it comes to robbery with violence, as covered under Section 296(2) of the Penal Code, robbery with violence is distinguished from simple robbery by specific aggravating factors. And these factors include, number one, being armed with a dangerous or offensive weapon. Secondly, being in the company of one or more persons. And thirdly, wounding, beating, or striking the victim. If you look at the case of Republic versus Ganzi and others of 2002, the facts of this particular case were that 3 people pulled a victim into her house, tied her up, and threatened her with a toy gun before stealing money. And so the issue was, can a robbery be classified as robbery with violence if the offenders were armed with only a toy pistol? And the rule is that when an offender is in the company of another during a robbery, it becomes robbery with violence under Section 296(2) of the Penal Code. So that the analysis of this particular case was that even though the weapon was a toy, the presence of multiple people being in the company met the legal requirement for the aggravated charge. So that the conclusion of this case was that the conviction was substituted with robbery with violence. The third offense related to property is housebreaking and burglary. Now, both housebreaking and burglary involve breaking and entering a building used as a human dwelling with the intent to commit a felony therein. Now, housebreaking is where the offense occurs during the day, but burglary is where the offense occurs at night. If you look at the case of Republic versus Gardiner of 1665, the facts of this particular case were that soldiers entered a house under a warrant to make an arrest. Once inside, some of them stole items. And so the issue was, is it housebreaking if the intent to steal is formed after lawful entry? And the rule is that the felonious intent must exist at the time of the entry to constitute housebreaking. And the analysis of the case was that since the soldiers entered lawfully to execute a warrant and only decided to steal once inside, the specific intent for housebreaking was missing at the time of the entry. And so the conclusion was that the offense committed was not housebreaking. Now, there are key defenses of offenses related to property, and the major one is claim of right. And that is simply an honest belief that one has a lawful claim to the property, even if that belief is unfounded in law or fact. And a good case is the case of Mwaura versus Republic of 1984, where the appellant removed a lorry from a police station because he honestly believed he owned it and had documents to support that belief. The court quashed his conviction as the taking was not fraudulent. So that is all I have as far as offenses related to property are concerned. If it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.